welcome to Gürkan Çakır's YouTube channel. Today I'm going to talk about inspection rights of LLC's shareholders under Turkish law. Shareholders of a limited liability company have a right to conduct examinations within the company in order to use their rights efficiently. Under Turkish Commercial Code, every shareholder can request information about company's business as well as accounts from the directors and also can conduct examination on certain matters. This right covers the request of any information or any document. However, it doesn't cover the records that are held at the companies concerning third parties. Company assets, financial obligations, relations with other institutions, company's affiliates, customers, suppliers, reports, as well as the future activities are within the scope of the term company's business. On the other hand, balance sheets, profits, reports, stocks and funds fall within the scope of the term company accounts. Documents do not necessarily have to be physically at the company's premises. Upon request, documents that are not found at the office must be provided to the shareholder, such as company documents that are held at law offices. Shareholders or a director who is also a shareholder possess these rights as long as the partnership continues. Shareholder may send the request to the director, but it is the company's obligation to provide the information. While making a request to receive an information, shareholders should specify the subject. Justification is not necessary for the request and no legal form for the request is stipulated under Turkish Commercial Code. Furthermore, requests can be made verbally or in writing. However, a particular form can be specified under company's Articles of Association. Company documents cannot be taken outside of the company. Examination should be exercised at the company's headquarters or at the workplaces in the presence of company officials. There is no regulation on when to exercise these rights, therefore, right to request information and examination can be exercised before, during, or after General Assembly meetings. No immediate response to the request is obligatory. Directors may take a reasonable period of time to respond to the request by taking into consideration the functioning of the company's business. The refusal must be based on an objective and justifying reason. If there is a risk that a partner who obtains information may use it in such a way that will harm the company, then directors may prevent the access to the extent that is necessary. When a shareholder's request is refused, General Assembly decides on the subject upon the application made by the shareholder. Turkish Commercial Code is silent on the form of the application. However, in terms of provability, the application should be made in written form. Following the application, directors should call a General Assembly meeting at the first opportunity to finalize the dispute. Right to request information and examination are fortified with the right of application to the court. If the access to information and inspection is prevented without a just cause by General Assembly, the shareholder may seek a court order to proceed. The court's decision shall be final and cannot be appealed.